Well, once again, I want to thank all of you for joining tonight for our Philadelphia District Attorney's Office virtual community town hall. Each month, our community engagement unit, we host monthly town halls to invite our community stakeholders, as well as you residents and those who work in the justice system, to be a part of a virtual conversation with members of our team and sometimes even some of our partnering agencies. And so on behalf of District Attorney Larry Krasner and our entire senior leadership team, we thank you for joining in tonight, and we hope that you enjoy tonight's discussion. Each month it's a new topic, or we're highlighting a different unit within the District Attorney's Office. And tonight I'm really excited that we're highlighting our Conviction Integrity Unit under the leadership of Assistant District Attorney Patricia Cummings. And we're excited about all the work that she and her team that they do each and every day. And so you're in for a treat tonight, and we look forward to hearing some of your feedback. We thank you for all who pre-submitted questions to our administrative team. And so I want to thank my staff, Seth Myers, my special assistant, as well as Andriana Bearfield, Kavan Green, as well as Donnell Drinks, who are part of our community engagement team. And so with that being said, I want to introduce our two panelists tonight from our Conviction Integrity Unit. I will ask that they just spend 2 minutes just talking about the work that they do and a little bit about their background as well. And so with that being said, I'm excited to introduce Patricia Cummings, as well as Sam Bass, who also works in our Conviction Integrity Unit. Patricia.
Thank you very much. It's a pleasure to be here and an honor. I'm going to try to give the shortest introduction I've ever given in my life because I think there's so much good material to get into tonight. So let me just say, I come to Philly via Texas. I've been a lawyer for about 30 years, and I've done a little bit of everything in the criminal justice arena except being a judge. I've been a prosecutor 3 times. I've been a defense lawyer. I've been a professor, and I've also been a lobbyist. I say that word and I laugh because a lot of people don't like to call themselves a lobbyist, but what I did is I worked the legislative session in Texas for 3 sessions, doing what I could to promote and actually get past criminal justice reforms. CIU work, despite all that I've done, is really what I'm most passionate about. It's the hardest work I've ever done, but it's the most fulfilling, and it's also an area where I think people who are passionate are most needed. I started the CIU work in Dallas, and I moved to Philadelphia shortly after Larry was elected as DA. So I've been here about 3 years, and I am so glad to be here and proud to be a part of a team trying to do good things for the community, individual by individual. I'm also very honored to introduce you guys to Samantha Bass. We call her Sam. She feels like she's my right-hand person in the CIU. She's a paralegal who helps day in and day out help us manage the many applications we get from inmates that are incarcerated claiming that they have been wrongfully convicted. So with that, I'm going to turn it over to Sam and let her talk about herself for just a few minutes.
Hi, everyone. I'm really happy to be here tonight. Yeah, as she said, my name is Sam. I'm a paralegal in the CIU. I grew up in Delaware County, and I went to school at American University in DC, and I studied criminal justice and philosophy. And while I was in college, I got to do a bunch of really cool internships, mostly in juvenile justice, and I graduated college fully intending to do juvenile justice work. After that. So I actually started at the DAO in the juvenile unit, and I worked in the truancy program as well as a violence prevention program for middle schoolers for a little bit. And then one day I was sitting at my desk and I got a call from, the higher ups saying that they wanted to transfer me to the CIU for just a little bit to help out Patricia. And turns out that was not temporary. And it has been just like the best experience. I said yesterday, I think that it's the best thing that happened to me by accident. So yeah, thank you.
Well, once again, thank you so much, and thank you, Sam and Patricia, for being our panelists tonight for our DAO virtual community town hall. For those who are tuning in, if you did not have an opportunity to pre-submit questions, you can feel free in the chat feature to send questions to Seth Myers, my special assistant, and we'll try to get your questions asked as well tonight. We have some general questions to start. And I know that Patricia and Sam have prepared slides for these particular questions. So Patricia, how does CIU's work fit into the DAO's mission of securing justice for victims and into DA Krasner's effort to reform the criminal justice system?
Thank you, and that's a great starting point. And I'm going to turn to Sam, who's going to put up the PowerPoint, because we've got a few slides that will help us kind of tackle that question. I'm going to give Sam just a second. I said a minute ago, I'm proud to be here. I'm proud to be doing this work. But the slide in front of you probably illustrates the pride that I have more than you can imagine. What you can see in front of you are photographs of most of the people that have been exonerated as a result of the work that Larry supports and the CIU does on a daily basis. That really is kind of the introduction to the question, answering the question of how our mission really supports victims. And I got to tell you, as Sam moves to the next slide, when you think about conviction integrity work, you've got to remember that what you're talking about is you're talking about people that have been wrongfully convicted. And I'm going to pause for a minute because I want to make sure everybody is using the same definitions, because wrongfully convicted can mean many different things. On the one hand, a lot of people are very familiar with the idea that somebody's wrongfully convicted if in fact they're actually innocent of the crime that they were convicted of. On the other hand is the much broader term of wrongful conviction as a result of the deprivation of a fair trial. So when we talk about trying to support victims, trying to engage in criminal justice reform through the work of the CIU to accomplish Larry Krasner's mission, we're talking about both. We're talking about trying to identify those folks that have been convicted and incarcerated for crimes they didn't commit, as well as those people that didn't receive a fair trial. Nationwide, when we look at what's happened in regard to those two categories, we see that Philadelphia is definitely not alone. We've got exonerations all over the country. And for those of you that pay attention to this topic, you know we really have only been keeping statistics on exonerations for probably the last 2.5 decades. But looking at the numbers from the National Registry of Exonerations, you can see that we've got almost 300 exonerations in that time period. And I think it's significant that we've got 48 in Philadelphia. What we do to try to achieve the mission, I think, of Larry Krasner in a CIU is we try to say, we want to look backwards to right the wrongs of the past. And only if you do that can you look forward to try to instigate or implement policies to actually make our criminal justice system a better system. So getting to the question of what does that mean in terms of our mission for victims, Sam, if you'll advance to the next slide, I want to tell you what so often people don't think about when we are facing this question, and that is a lot of times people will think of this work only in terms of trying to free the innocent, trying to exonerate those that are wrongfully convicted. And of course, that is the first and foremost objective in this kind of work. But it's so important that we all understand that when we are talking about somebody who has been wrongfully convicted, we've got to understand that the damage is not just to the defendant, the individual that was convicted, but damage has been done to the victim. Damage has been done to the system as a whole. And I'm going to stop for a second. I'm going to back up to those last two bullet points because I think it's so important for folks to know, at least from our perspective as prosecutors, that we are very mindful. Every time we look at one of these cases, we are mindful of what does it mean to the victim. And we have all kinds of victims. Obviously, a lot of what we do are homicide cases. So what we're talking about is the victim's family. And what happens to a victim's family when you have to make that phone call or you have to have that meeting and let them know that, oh my gosh, the person that was convicted, the person that you thought murdered your loved one is not really the person who did it, what happens then is a whole process of re-victimization. And so there's so much that you have to be aware of to try to figure out what can you do to try to not exacerbate that more than it already is exacerbated by the fact that you're essentially ripping off sometimes decades old Band-Aids for people who think that they have actually gotten justice and solved this terrible tragedy that happened in their life. So the victims are so important. And one other note that I want to make about that is the office tries very hard to pay attention to victims in terms of cases going forward. Those are the cases where you're pre-trial, you're arresting somebody and you're trying to prove that they committed a crime and convict them in the first instance, and you deal with victims in a certain way there. But when you're talking about the wrongful convictions and you're talking about cases that could be 20, 30, 40 years old, we recognize that there's a whole different type of trauma that those folks are faced with. So in addition to using the normal resources that we have in the office, which are victims assistance coordinators, we also often tap into experts in the field of victims advocacy and assistance in wrongful convictions. And I just want to quickly just do a shout out for this nonprofit organization called Healing Justice. And for those of you that are interested in this topic, you ought to Google them. Jennifer Thompson is a fascinating, wonderful person who does so much for individuals and the criminal justice system. She, in fact, was an actual victim of a rape decades ago, went through the process only to find that the person that she identified in a photo lineup, who she absolutely believed was her assailant, actually was not. DNA later proved that the person was in fact innocent. Jennifer Thompson, because of that ordeal, committed her life to helping victims and helping educate to deal with this kind of unique facet of the criminal justice system. So there are plenty of times when we're dealing with cases and we're talking to victims that we're referring them to Healing Justice because it is kind of a specialty subset of what it means to be a victim in the criminal justice system. Quickly, because I could spend a ton of time on that, and I know we've got a whole lot of material to cover. I want to also make note that in addition to the defendant being damaged or suffering from a wrongful conviction, everybody has to understand that our entire criminal justice system and our community suffers as well. Our criminal justice system suffers because we spend a ton of resources thinking we're getting the right person only to find out that we didn't, and then we start all over again. And with that comes a lack of confidence in the criminal justice system and our ability to get it right. And I will say, almost as important, if not more importantly, it's so absolutely critical to understand that when you convict the wrong person, not just talking about somebody who didn't get a fair trial, but I'm talking about the wrong person in the sense that you have convicted an innocent person, then what you are necessarily doing is you're allowing the true perpetrator to go free. You're allowing the true perpetrator to go out and commit other crimes. And so from a community public safety point of view, that damage is immense. And so by looking back, trying to correct the mistakes of the past, we learn how to try to prevent them in the future. And by doing that, I think we learn how to make our community safer. So Sam, if you'll go on to the next slide. Is it kind of sticky? So before we go on to the next question with G. Lamar, I just once again want to highlight, I've talked from the victim's perspective and how we try to advance the mission of criminal justice reform under Larry Krasner, but I also want to highlight just some additional cost when we talk about wrongful convictions. And those costs can be seen on this slide. When you stop and breathe or pause for a minute and you look at the numbers. So remember, I told you just a little while ago that of the national number of exonerations that we've had, which is close to 3,000, we've had 48 so far that have been identified in Philadelphia. You look at how many years in prison that means when you've convicted 48 people that you shouldn't have convicted. The human toil on that is unbelievable, not to mention the cost to the community, all the money that we're spending incarcerating folks that shouldn't be there. I mentioned a little while ago that another aspect of the cost and the victimization that's suffered as a result of wrongful convictions is that the true perpetrator is often left to be free and able to commit other crimes. We've actually now been able to study cases, and if you will look at it and you want to delve into this a little bit more, normally what we look at are the DNA exonerations, because so often the DNA exonerations kind of lead us to who the true perpetrator was. We are able to not only identify them, but oftentimes prosecute them. And then we study those cases. And in the case that's listed in the bullet point on the slide in front of you, you can see here in Philadelphia, this was a sentinel review done by the Quattrone Center, where they actually looked at a case where the wrong person was being prosecuted. And by studying that, it actually led to not only exonerating that person, but helping identify who the true perpetrator was, which was actually the person's brother. Once again, I'm going to highlight, anytime we're talking about any of this, 761 years in prison for people that shouldn't be there, getting the wrong perpetrator only to find the right one later, it all breeds distrust in the criminal justice system. And we have to do everything we can as stakeholders in the system and as community members to try to figure out how can we try to fix that? How do we climb the mountain to try to minimize that from reoccurring in the future? Next slide, Sam. The last quick comment I'm going to make is that I think that we not only have a legal obligation as lawyers working in the system, we actually have a moral obligation to do what Larry Krasner is committed to do. And put as simply as I can put it, that means what we have to do is we have to look, we have to listen, and we have to rectify. And I can't say this enough. That means looking backwards, that means looking forward. And if we look backwards, it helps us improve the criminal justice system going forward. And I wish I had more time to talk about this, but it also gives us the ability to try to change policy, to try to have an impact on our legislature so we could actually pass laws to help rectify the mistakes of our past. And the example that I have on this slide is that CIUs, like the one in Philadelphia and ones throughout the country, do lots of good things, and that is they go to state houses and they say, hey, look, let's try to rectify this. Let's pass compensation statutes, for example, to where we can try to give back to the wrongfully convicted what was taken from them through a broken criminal justice system. As you can see from this slide, 35 states have done it in this country. Pennsylvania is not one of them. The CIU here in Philadelphia is committed to try to do what we can to help and to try to make sure that we give these people the tools that they need to come out of long periods of incarceration to where they can be productive members of society. And I think, G. Lamar, that's it on that first one. So we'll go into what your next question is.
Certainly, and there it is on the screen. And the question is, can you please describe the conviction integrity unit's structure and purpose within the DAO?
Great. So Sam, if you'll advance that slide. So simply put, when we think about the purpose of the CIU, I think this slide really kind of says what we do, and that is we look at past convictions for credible claims of actual innocence, wrongful conviction, and where feasible, sentencing inequities. So if our mission is to rectify the mistakes and the harms of the past, we've got to figure out how we define that. So as a unit here in Philadelphia, our purpose is to be committed to look at cases where folks are saying to us, I'm either actually innocent or I was wrongfully convicted, or my sentence is unjust. And so what we do is we have to devise a way of trying to kind of wrap our head around all of those requests to do it. And in doing that, we've got to say, this is how we're going to try to accomplish the goals or the mission that Larry Krasner has kind of set for himself, our office, and our unit. So going on to the next slide. A lot of folks, when they just look at the one we just had up, says, well, what does that exactly mean? I mean, what does it mean you're going to look at all of those cases? And it's really kind of hard to answer, because when you have about 2,000 people saying, look at my case, and you've got them saying all kinds of things went wrong, you have to identify a way that you're going to go about looking at those cases and trying to identify the ones that truly are wrongful convictions. And so what we do in the unit is we have set up a process for reviewing submissions, is what we call them, submissions or applications. And that is anytime we've got an individual saying, look, I have been wrongfully convicted. And with that process, what we do is we try to gather information about the case, and that's going to include everything from police files, trial files, post-conviction files, and what the actual applicant or person submitting the paperwork is saying to us. We look at what they're saying, we look at what the records say, and we try to discern whether or not there is, in fact, a credible claim that really requires us to jump in and investigate more to determine if there's any new evidence that exists to show that we got it wrong. And oftentimes, that new evidence could also be evidence that was suppressed or not disclosed. And I'm sure most of you guys have heard in the audience that a lot of the exonerations we've had here in Philadelphia have involved cases where either the police file or the prosecutor's file had information in it all along that suggested that the defendant who got convicted may not have been the person that committed the crime. So we are doing as much as we can in terms of coming up with a process to figure out how to look at the information, how to digest it, and how to figure out identification of those folks that did indeed get an unfair trial. So the next slide, Sam. I'm going to let Sam talk for just a little bit here in a second about this, because it's so important. I've talked about inmates, and really we refer to them not as inmates. They're individuals who've been wrongfully convicted, but we also rely on the legal term that is so often used in the criminal justice system, which is if it's an individual who's incarcerated, who doesn't have a lawyer, we call them pro se petitioners. They are representing themselves. And the vast, vast majority of requests we get are from those types of individuals. So that's like the big bucket of cases we're asked to look at. Another bucket we're asked to look at is cases where somebody is incarcerated, but they actually have a lawyer representing them, and the lawyer is coming to us to make the case as to why the lawyer believes their client is innocent and or wrongfully convicted. Sam, I think it's probably good for you to pipe in just a little bit to talk about the pro se petitioners and how you spend so much of your time helping us create the process for reviewing those cases.
Sure. So as Patricia said, we have about over 2,000 pro se cases in our queue right now. So, you know, that means it takes a lot of time to figure out how best to really look at those. And that has really been a lot of trial and error. And we've, you know, gone through a few databases and, you know, just trying to figure out really the best way to be able to, you know, fairly look at each one of them and give them the time that they need. Especially when, you know, they don't have the benefit of having an attorney come to us and tell us exactly what the issues are. So it does require a lot of reading through the petitions and really understanding what it is that they're trying to get at. So, you know, we've really been trying to figure out the best way to do that, but also try to do it, you know, in somewhat of a timely manner so that we don't have people just sitting around waiting for us to respond to them.
Head on to the next slide, Sam. I think we've maybe advanced a little bit further than we should have, did we? G. Lamar, you want to move on to the next question?
Yeah, so the next question is, how can community members submit cases to be reviewed by CIU?
That's going to be me teeing it up a little bit for Sam as she kind of gets to the spot where we need to be in the slideshow. And I will say this has also been a bit of a work in progress. And let me kind of explain why. When I started working for the DA in February of 18, I think so many people in Philadelphia really knew a whole lot more than I did about what Larry had in mind for the Conviction Integrity Unit. And the reason why I say that is within probably just being here a couple of months, we were getting buckets, literally buckets of mail from individuals that were incarcerated submitting pro se applications to us. And I hate to say it, but it's true. We really weren't prepared for that. We didn't have a process in place for dealing with that kind of quantity of requests. And so we found ourselves quickly having to scramble. And the scramble was as basic as how do you make sure you're opening the mail, much less reading it, to how do you process it to make sure that these people are getting their applications looked at, that if the application is insufficient, how do you get more information? And then how do you proceed to the point of actually looking at cases? So basic to open the mail to more advanced to what's the best way to try to help these people get the right information to us? How can they help us help them? And so we had to come up with a CIU application process. And in the old days, before Larry became DA, when the CIU had just been in existence for a short period of time, they did have some process in place, but it was very different than what we have now. An example of that is they had a 3-page application that they asked individuals to prepare and submit. As we started looking at it and looking at all of the letters we were receiving, we thought we really want more information from people so we can really try to figure out if there's something we can help them with. So Sam, if you'll advance on to the next slide, I'm going to turn it over to you and have you talk just a little bit about the slide that's in front of everybody right now.
Sure. So this is the first page of our 16-page application form for pro se petitioners. It's a long application, and of course we understand that, but it really does help us get to what we need to know, and ask them all sorts of questions, all sorts of details about the case, including things like who were the detectives on your case. Did you plead guilty? Like, tell me about the trial, tell me about, all sorts of things. So that's what this is. Yeah.
And then, G. Lamar, to kind of specifically answer your question, how does the community know about how to get the application to us? That's something else that we've struggled with as well. We really want to get to a point where everything could be done electronically. Where applications could be submitted to us via email, because we know that that's going to be a lot easier and a lot quicker. But at the same time, let me tell you 2 big limitations we have. One limitation is just dealing with the Department of Corrections and people's ability to actually get the information reduced down into an electronic document so that it could be sent to us. And then quite frankly, the limitation on the other end is the infrastructure in our own office. We've been in G. Lamar, I don't know if this is something that you've talked about in other community engagement events, but one thing that we've been trying to do is get the DA's office into the 21st century as far as being able to use technology. So we're better able to communicate with the community and the people that we serve. And so one thing that the CIU has done is to try to update the particular section in our website about information folks need to have about how do you submit an application. So we've done a little bit of that. There's a little bit more in the works. And I think that will help everybody in the community in terms of whether or not they're trying to help somebody that was a friend or a neighbor or a loved one. So hopefully it's going to get better. One thing for sure we've gotten better at is we're not as formalistic as we were before. In other words, some of the rules of the old Conviction Integrity Unit, and quite frankly, existing units in other places in the country, they say things like, if you don't fill it out exactly as we say, we're not going to accept it. If it's not signed by the actual individual who's claiming the wrongful conviction, we're not going to accept it. We have realized that that is absolutely not the way to handle this. What we do is, even though we use this long form, we want to encourage people to give that kind of information. But at the end of the day, if they give us something that's short of that, but we can look at it and we can discern what their claims are, we're going to accept it. If their mother submits something to us, we're going to accept it. We're just going to have to turn around at some point and make sure that the actual individual is willing to sign off on something to understand what the rules are of a CIU review. But we're trying to be much more user-friendly to say, look, our objective is to try to identify the wrongful convictions, not get so caught up in technicalities that we're shutting the door on a lot of people. Next slide, Sam.
Quick
Lamar, do you?
Yeah, one question that just came up, Patricia, is how, and I know this is consistent with a question that's coming from Shuja Moore from the Enterprise Center out in West Philly. But how, and good to have you on, Brother Moore. How does it, someone, if they want to check up on the status of their application, what's the process for that?
So I appreciate the question. I'll tell you it's a difficult one because what we struggle with as a unit is we so much want to keep people informed. But the reality is our backlog is so immense right now that, as Sam was mentioning, we've got so many people that what we call it, they're just in our queue, our queue of 2,000 cases. And when we started, and this is on a slide we'll see later, when we started under Larry, we had 2 prosecutors in the unit with no support staff. Thank goodness Larry has kept his promise of giving us people and resources. So now as I sit in front of you all today, I'm proud to say we have 13 prosecutors and 5 staff members. So, I mean, it's light years from where we were, but the truth is it's still not enough. When you think about the cases that we're looking at, which are predominantly homicide cases, and they're old cases, and you then start to understand that one case, if you take it from beginning to an exoneration, and we'll talk about this in a little bit, that one case could take 2 to 3 years worth of work. And then you start doing the math. We've got 2,000 people saying, look at your case. It's really, really hard. I was telling somebody yesterday when we were having a conversation about this, I was saying, I think that our backlog is such that with the staff we have right now, it could take a decade to get through all of the cases. And I know that's not what anybody wants to hear, but it's the truth. So how does that, G. Lamar, kind of segue into really answering your question, which is making sure that we're letting people know what's going on with their case? Well, unfortunately, the reality is the vast majority of the cases, we don't really have anything to tell anybody. The best we can do is we can say, as the slide shows in front of you, that we have received your submission. That means it is being processed. That means it's going in the queue. Or we may be able to say, we got your submission, but you know what? We don't have enough information to really process it and review it. So then we'll send a letter saying we need more information. So when there is something going on with the case, we do our very best to communicate with the individuals so they know what's going on. When it comes to talking to the community, loved ones, family members, friends, I wish that every single time somebody sent us an email or they called us, that we would have enough minutes in the day to say, hey, I know it matters and we care, but we don't have anything to tell you. And if we had the resources, we would do that, but we don't. And so we often have to make hard choices about how much of that can we do versus how much time do we have to actually look at the cases and get the work done. Long way of saying, G. Lamar, we do the best we can, but we'll be the first to admit there are plenty of emails that come into our inbox that don't get an answer because we don't have anything to tell them. And sometimes it's just hard to say we don't have anything to tell you. Rest assured that we do want people to understand that if the case is moving, if something is happening and it's something the individual needs to know, they will be told that something's happening. Likewise, if we've gotten the case, and I think, Sam, this may be on the next slide, if we've gotten a case that's come into our queue and we've looked at it and we have made a determination that either, number one, our unit can't even handle their case, and that may sound really weird, but we do get requests from people that aren't even in Philadelphia. And so we can't do anything about their case because we've got no jurisdiction over it. We do get requests for people that don't fit the definition of being in custody to where we could even do something for them legally. So in those situations, we try to let them know that, sorry, we're declining it. We can't help you. Other than the mandatory, where there's absolutely nothing we can do, we also will get another kind of bucket of cases where, yes, it is a Philadelphia case. Yes, they're in prison, but there's something that they've told us in their letter or the files tell us that say we can't help them right now. And honestly, everybody, sometimes that has a lot to do with resources. And so what we have decided as a unit is we would rather let people know if we can't help them rather than letting them sit in our queue for 2 years. So we try to let them know that as well. So, Julimar, is that answering your question? It may not be the best answer, but it's a truthful answer.
Certainly, we appreciate that much. Sam, if you could just unshare the slides for 1 second. We're going to go into the other portion of questions just so we can get into some of the pre-submitted questions. And again, if you're just tuning in, thank you so much for joining us. This is the Philadelphia District Attorney's Office, our monthly virtual community town hall, and we're extremely appreciative for all of our stakeholders and community members, as well as our elected officials and faith leaders who have tuned in today. Even some of our law enforcement personnel, we've seen Captain Rodriguez joining us, and glad to have you on, and all of our stakeholders on today. Our next question, or our first question, I should say, from the pre-submitted list, it's coming from Dr. Tony Damon. She is the principal at Dobbins High School. Always good to have you on, Dr. Damon. The question is, Patricia, what factors determine who is exonerated?
Thanks, Dr. Damon. That's a great question. And I will try to answer it as succinctly as I can, because that is also a question that you could spend about an hour trying to give you a full and complete answer. I got to say, for the short answer, what factors, I tend to kind of come up with categories. Of course, one of the most important type of factor for us as lawyers is we've got to say, what is the law, and is there a legal ability that's going to give us the tools we need to actually exonerate somebody? And so what I'm talking about there, Doctor, is that you really have to understand whether or not we're dealing with a case in federal court or in state court here in Pennsylvania. Is there some mechanism that we can avail ourselves of on behalf of that individual to say that this person was indeed wrongfully convicted and that they are entitled to a new trial? You've got to have more than just the legal mechanism. You've also got to have what I would call the facts, and just be aware of practicalities too, in terms of trying to ascertain what's going to allow somebody to ultimately be exonerated. And kind of the magical phrase that we hear over and over again, and we tell people all the time, is more often than not, there's got to be some sort of new evidence that the original jury or the original judge in the case didn't hear. And now we've got the information. And if you had heard that, then that means you probably would have come up with a different result, i.e. you wouldn't have convicted the other person. So you got to have the law. You got to have the evidence to support the exoneration. And then I'm going to say one more factor that I kind of hate to, but we've got to face reality, and that is kind of the practicality of it all. Sometimes the practicality is, somebody may think that there's new evidence out there because somebody said something, but we're not able to get our hands on it. Somebody may say, hey, you know what would exonerate me is a DNA test. And then we find out, oh no, they didn't collect any biological material to test, or oh no, they did, but they lost it, or it's degraded so much that it doesn't have any value. So you've got to think about those practicalities of whether or not you're going to be able to get your hands on what's needed to be able to prove under the law that an exoneration is the just and right thing to do. The last practicality, Doctor, that I want to point out is you also got to understand what world you're in. And what I mean by that is if you're in state court, who's the judge that's hearing the case? If you're in federal court, you ask the same question. The reality is we all understand that there are some people that are more old school, old culture, and they don't believe that our system has got it wrong. They don't believe that we've convicted innocent people, or they believe in finality. They believe that once somebody's convicted and their appeals are over, that should be the end of it. We need to move on. And so you've got to face the practicalities of that is the world we live in, and how is that going to affect the ability to exonerate somebody who's been wrongfully convicted. Hopefully, Doctor, that answers your question.
Thank you so much, Patricia, for that response. Just before we get into our next question, I want to give some quick shout outs to all those who are viewing right now. But good to see you, Carlene Neal from Omega chapter of Alpha Kappa Alpha Sorority Incorporated. Rep Darisha Parker, we see you on. Senator Street's office, Councilmember Brooks' office. Charles Reeves from South Philly, good to see you, man. Reverend Harold Jolly, Reverend Dr. Suzanne Kershaw, Archbishop Palmer, good to see you on. Saya, good to see you from Harold Gate Civic Association. Deacon Wayne Johns from Sharon Baptist Church, Urban League of Philadelphia. Just want to give a few quick shout outs before we continue. Our next question is coming from Martha Gilnett. She's from the Salvation Army on Rising Sun Avenue. Are there any cases that the Conviction Integrity Unit declines to investigate?
Quite a few. And I'm going to tell you, in some respects, that kind of goes back to the numbers. It's just not possible to be able to investigate all of them. And probably a good way to try to illustrate this more for you guys, and I'm not sure if I've used this phrase or not, we really try to triage our cases. We do not have the ability to do a full-blown investigation and merits analysis for every single person who writes into our unit. If we did, quite frankly, I would say we probably would not be a conviction integrity unit. We'd probably be a conviction integrity and law division and appellate and post-conviction, because you'd have to have so many people doing it. We don't have the ability. So we have to try to figure out, and it's a hard process, we have to try to figure out which are the cases that we have some indication that doing a full-blown investigation is going to lead to the ultimate exoneration. So Sam's got a slide, I'm not sure that we'll get to it, but yes, I mean, we decline cases quite often. I think we've declined somewhere in the vicinity of about 300 cases at this point. And I would say almost every single one of those were declinations based on a review of the submission and application and a review of the file. It wasn't a declination that was done after going out and investigating and interviewing witnesses on the street.
Thank you so much. Our next question is coming from Movita Johnson Harrell. Good to see you, Miss Movita, from the Charles Foundation. Her question is, how far behind is CIU in reviewing cases? Is there a system that prioritizes which cases are reviewed first? I know you got into that a little bit, Patricia, but if you can maybe go on that for a couple more minutes.
Hi, Movita. How are you? Good to, I don't get to see you, but I'll pretend like I'm seeing you. I'm going to flip your question, and I'm going to start with the prioritization, and then I'm going to go to how far behind we are. Because I have talked a little bit, I think I mentioned a decade is probably what it would take to get through all of the submissions that we have, that we currently have. But the prioritization, I got to say, is something we spend a lot of time on, and it's really difficult to figure out how to do it. There are some people, that's kind of, they look at it more egalitarian, and they would say, okay, what you do is you just prioritize based on the day the submission comes into your unit. So if you got a case on January 1st and another one on January 5th, well, then obviously you look at the January 1st one first. That's not practical from our point of view and what we know about this kind of work. So what we do is, although we look at the time when we get it, we also have decided what are other important factors that we should consider when we're trying to figure out how we prioritize the case. And some of those factors are, how long has the individual been in prison? What kind of sentence are they serving? What kind of claims are they making? What detectives were involved in their case? How worked up is the case? In other words, are they giving us an application with lots of supporting materials that make it easier to discern whether or not there's something there? So these are the factors we look at, and we really, kind of to a painstaking degree, will look at the submissions and we will try to rank them, and we'll come up with, this case should be a priority 1 level, this one may be 2, this one may be 3, and then we try to look at the ones that are 1 first, and obviously on down the line. And I gotta say, so far, we're probably doing a little bit better in terms of the cases that come to us from attorneys as far as that prioritization is concerned, rather than the pro se applications that we've gotten. And part of that is the pro se applications they've just been a challenge because there's so many, and we're trying to figure out, how do we process them? How do we then screen them? And so I'm proud to say, and I'm going to go into the second part of your question, Mobita, which is how far behind are we? And recognizing how far behind are we realize it's not so much just coming up with the process, but it's also trying to figure out what's the best way to get qualified people helping us look at the cases to figure out if it's a case that's going to move forward or a case that's going to be declined. And I want to share with you guys, as we were brainstorming, trying to figure out how to do that, I researched the issue, and some CIU units in the country that get a high volume number of pro se applications have gone and asked for federal funding, federal grants, to partner with Innocence Projects to see if they could get the Innocence Project to work with them to help review the applications and, like I said, screen them and figure out if they advance. We looked at that, and we thought about it, and we ultimately decided not to partner with the Innocence Project in Pennsylvania, although we love them and we work with them regularly. We decided not to partner with them because their mandate is they only take on clients with actual innocence claims that they find to be credible. They don't have the broad umbrella or funnel of looking at wrongful convictions and sentencing inequities like we do. So we thought, if we're going to collaborate with somebody, we need to collaborate somebody that has the same type of umbrella or funnel that we do, and at the same time is qualified to do the work. So I'm gonna do a shout out right now to Jenny Merrigan, who is also present for this panel discussion, and I'm going to pull her in just a minute, and I'm going to have her talk to you guys about what we're doing. But thank goodness, in trying to brainstorm to figure out how to deal with our backlog, we worked with Jennifer Merrigan and her nonprofit law firm, Phillips Black. We got grant funding to fund the project, and now Jenny is officially part of our pro se team to help us look through these cases and get through the backlog. So Jenny's on now, and I'm going to turn it over to Jenny for just a couple of minutes and let her introduce herself and the team, and then maybe say some things that'll make people breathe a little bit of sigh of relief that we're going to get through that backlog a little quicker.
Thank you so much, Patricia. So yes, I'm Jenny Merrigan. I am an attorney with Phillips Black. We're a nonprofit, and we handle post-conviction representation of prisoners around the country in death penalty and life without parole cases. And we, a couple of years ago, had the opportunity to collaborate with Patricia and her team in the case of Bilal Wilson, who was exonerated last year after spending 28 years in prison. And so through that experience and working with the CIU and being exposed to the really amazing work that they're doing, and in conversations with Patricia, we just realized that there are so many pro se cases that need to be addressed and evaluated. And that is in our bailiwick, is working with prisoners who do not have representation to evaluate their cases. And so right now we have, as Patricia said, funding for a year to do this. We have a team of 5 in our office. And so we're really excited to see what we can get done.
It's just fantastic. I'm just clapping as I listen to you, Jenny, because it's so exciting. And I do want to add one thing to what Jenny said, and I think it's important for everybody to know. We're kind of dividing up the resources of Phillips Black into two categories. The first is going to be that they are actually going to be part of our team in kind of wading through all of the many documents and applications we get. And so we're going to use them to help and use their expertise, quite frankly, to help us figure out how to better triage the cases, which are the ones that really look like they were wrongfully convicted or they're actually innocent. That's the first part. The second part is, and this is super exciting to me as well, but the second part is once we identify them, if we get to a point in the investigation where as prosecutors in the district attorney's office, we believe that individual is entitled to a new trial and possibly entitled to have the case dropped and be set free from prison, we then have lawyers with Phillips Black who, assuming the individual who's incarcerated wants them to be their lawyer, will have, it's like a match made in heaven if they do, because we will be able then to go into court and effectuate, what we are striving to obtain, which is the exoneration of innocent people or wrongfully convicted people. Thanks, Jenny.
Thanks, Jennifer, for your responses, and thanks, of course, Patricia, for that question. The next question is coming from Michael Butler. Michael is a part of Man Up SCI Phoenix, and also he works for the Institute for Community Justice, Kawi, as we call him. Good to have you on, and all the brothers from Man Up. Major shout out. The question is there a process for someone who has a compelling case for innocence, who has behaved admirably during 23 years of incarceration and has countless accomplishments while incarcerated and has strong community support for returning to society? Is there any way that a restructured sentence could be made available to a person in this situation?
Hi, Michael. I kind of wish I would have gotten that question from you about 3 years ago when Larry Krasner and I did one of our first media statements together, because we were asked the question about how do you tackle sentencing inequities. And at the time, Larry and I both just said, not really sure how you do it, but I can guarantee you we want to do it. So it was at that point that we expanded the purview of the unit to cover the sentencing inequities, because we absolutely recognize, Larry and I both did criminal defense for many years, and we know there are many people in prison that fit into that category. So we certainly had the desire, but it didn't take long for us to figure out that there are not a lot of tools available to us in our criminal justice system to allow us to do that. Right now, I don't know if many of you guys in the audience are policy geeks, but there's a lot of states throughout the country that are proposing legislative reform called Second Look. It's an ability to go in and say, we thought this case warranted a 50-year sentence 20 years ago, but we know better now. And so the Second Look effort or legislation is trying to figure out how to give prosecutors and judges the tools to go back and say, we're going to change those sentences. Hasn't really hit Pennsylvania yet. So, Michael, how do we do what you just asked? And fortunately, even though we don't have the tools that I think we need to do that, we do have some ability to right those wrongs. And I've got two examples of it. One is what we have found is sometimes you can look at a case and you could see that something went wrong during the guilt-innocence phase. And it was enough to say that the conviction is not valid, but it's not enough to call into question whether or not the individual committed the crime. Instead, what it is it's a hook to be able to go in and reset the clock and start over. So then you could also re-sentence an individual. So let's say they had a 99-year sentence, and then you go back and redo it and you get a 20-year sentence, and guess what? They've already spent 22 years in prison. So that's one way, and we've actually done that in 4 cases. Those don't count in our numbers for exonerations because they're not really exonerations, but it is 4 very important events in 4 individuals' lives, where now that they've been given an opportunity to go back into the community and be productive members of society. The other thing that we are doing, and some of you guys may know a little bit about this, but we are actively involved in the commutation process. And we are proud partners of the Board of Pardons and their efforts to say, when is enough enough? We've got so many aging individuals serving life without parole, and so many of those people have served well over 30 years in prison. So there are lots of stakeholders in Pennsylvania right now that are saying, even though we haven't done it for decades, it is time to use the executive power, the executive branch, to say, we're going to commute sentences of worthy individuals, individuals that are worthy of mercy, such that they can get out of prison and they can become members of the community and productive, not only for their family, but for the community as well. So those are the 2 big things that I think are addressing your question, Michael, that we're able to do. And we absolutely intend to continue to do it and grow it so we can hopefully help many more people.
Thanks, Patricia, for that response. Colby, aka Mike Butler, thank you for your question. Next question is coming from Donna Clement Jones. She's from Councilmember Derek Green's office. And Donna, good to have you on. Please send our hellos to the council member. Are people eligible if they were convicted in Philly, but have since been transferred to another state or jurisdiction? Are they eligible for their cases to be reviewed?
So I want to make sure I understand the question before I jump into it, because part of me says that sounds like the conviction and sentence is out of Philly, but for some reason they're serving time maybe on another sentence in another state.
Correct.
Donna, am I getting that right? Is she able to answer you, Lamar? Or
I'll see if she sends something. Yes, that is that's her question.
Yeah, I'm going to say they're not ineligible, but I'm going to give you a practical answer. And the practical answer is they probably would not be high up in the queue because of our priority system. Because what we want to do is we want to try to prioritize the cases where we could actually get somebody exonerated who's worthy or deserving of it and actually get them freed from prison. So if, let's say, they've got the Philly conviction, and let's say the other state is California, and they've got the conviction in California, we've got no ability to do anything about that California conviction. So if we were spending a ton of resources to deal with the Philly one, only to recognize that they are still going to be stuck in California serving a life sentence, you see what I'm saying? You have to make hard choices. That's not to say that if the Philly conviction's a wrongful conviction that changes that. It doesn't. It just really affects our priorities in terms of how do we triage the many cases we have, and how do we try to help people that really may have a legal ability to be freed from their wrongful incarceration.
Thank you so much, Patricia. Just before we go into our next question, want to again thank all who are just tuning in. This is the District Attorney's Office monthly virtual community town hall. And today we are discussing or highlighting our Conviction Integrity Unit under the leadership of ADA Patricia Cummings, as well as our other panelist, Sam Bass, who does some extraordinary work in the Conviction Integrity Unit. I want to give a quick shout out to Reverend Antonio Anderson, who's tuning in, Dr. Sherry Jones, good to have you on. Executive Director for Northwest Victim Services, Melanie Nelson, so glad to have you on, as well as Rebecca Curry, glad to have you on as well. Our next question, actually 2 people asked the same question, John Thompson, as well as Betty Jean Nobles. If a person has been paroled or already served their time, they're released now, can their cases still be reviewed?
If they're completely released and they're no longer serving a sentence, the answer is probably not. Pennsylvania law is pretty strict about what cases actually fall within what we call the Post-Conviction Relief Act statute, which is really the habeas writ statute. Parole, they still would be under the sentence. But once again, you guys, I'm going to harken back to the priority system. If we have somebody, all things equal in terms of factors we look at for prioritization, where we've got somebody who's still in prison versus somebody who's on parole, chances are the person who's in prison is going to get the look before the person who's on parole. I will say, for both parts of that question, we want to start educating and communicating more with the community about you can, even though you may not get a CIU review in that situation, you can try seeking a pardon, or you can try seeking a commutation, which would be to end the sentence. We're exploring with the Lieutenant Governor's office how to deal with the pardons, and I'll tell you, this office is doing a really good job for those people who are no longer serving a sentence and they're actually seeking pardons. And if anybody went to the Board of Pardons website, you'll see that the numbers are increasing in terms of people that are being granted the pardon. That's if they're not serving the sentence anymore. But yeah, the short answer is it really will probably boil down to a prioritization. And most of the time, the person that's serving the sentence in prison is going to get the look quicker.
Next question is coming from Rebecca Curry. She is if I remember, Rebecca, the reentry specialist with PA Career Link, which is one of our partners for our monthly one-stop job and resource hub. Glad to have you on, Rebecca. She, as well as a attendee named Martha, they're raising the same question, and that is, what resources does the unit need to improve? As well as Rebecca's question is, what can community members do to support CIU?
So let me start with resources, and then I'll talk about just support in general. And I think Jenny and Sam and Tom, I want to do a shout out to Tom Gaeta. He's a member of our unit who's actually here tonight. I think all of us would say one thing we desperately need is to kind of harken back what I talked on a little while ago. We need to move into the 21st century, and we need to have an office that has technology. We need case management, a database system. And one of the things that we spent a lot of time on in putting together this collaboration with Jenny and Phillips Black is to try to figure out, can we carve out some of the money from the grant in order to create a case management database system. And the reason why that's so important to us is because I think most of you guys will know, if you have that, your ability to search cases is going to be exponentially quicker and more effective. Good example is some of you guys that may be familiar with some of our exonerations, you'll see that there's some common themes or threads throughout. Without going into names, there are certain detectives that have played significant roles in major cases that have led to exonerations in the city of Philadelphia. So if we had a way to actually kind of flag and search cases so that we could say, hey, look, if that detective was involved in the case, that might be one that's going to go up higher on our priority list, it would make things a lot easier. We're struggling because we don't have all that right now. We certainly have Larry, who's on board for trying to get the office to where it needs to be, but we're not there. So when I think of resources, I think of technology because it's just on my brain, because as we kick off this Pro Se project with Phillips Black, it's something that would make it a lot easier. As far as community support is concerned, what I think is really important is trying to get more people familiar with what we do. And I say the reason why that is so important is really twofold. One, I think the more people that are aware of it, I think the more you can share it with other people, so we're not looked at as these crazy liberals who are just trying to set everybody free from prison. That's not what we're doing. That's not what our mission is. And so if people understand that what our mission is, I'm going to say, and I don't know if it's a good thing or not, but what I'm going to say is our mission is really not a partisan mission. It's not a Democrat or a Republican mission. It is about getting it right. and getting it right in one of the most serious things we do as human beings, and that is getting it right when our system says we're going to deprive somebody of their liberty. That's what we're about. And if we can lean on the community to help us get the word out, I think the naysayers maybe can be turned, and they will understand that this is something that we all benefit from. So that's one. The other thing I think that the community could do that would be so helpful is knowing more about our process. And Jill and I, this is why I'm so thankful for doing this tonight. When we can talk about our process, what our struggles are, how many people are coming to us, if people know that and help us communicate that message to folks that are writing to us, maybe they will understand that we're not ignoring them, and it's that, not that we don't care, it's that what we're trying to do is figure out how to take a little bit of resources and make it go as far as we can. And sometimes that means we're not able to return every phone call or every email. And I know that sounds terrible because I think everybody wants their phone calls and emails returned. But if people understand the process, maybe they won't be calling to ask about the process. One thought that we had, and this was actually Tom's idea, and it was really a good one, is we would like to get to a point where we're either going, some of us, to the prisons, or we're getting information out in newsletters, so that way the individuals that are in prison can hear the message that we're sending tonight. And if they understand the system better, then they maybe will be able to, I hate to say be patient, because I don't want to say they're impatient. I can't imagine what it would be like being in prison for a crime you didn't commit. You don't want to be told you're impatient. But we're constantly trying to figure out, how do we get the word out? The pandemic hit, and so we can't really do that. So the community can help us by us educating the community and keeping the community informed. Then I think they can kind of be our spokespeople for us at times when we need it.
Listen, if you're tuned in, thank you so much for being on tonight. We have about 20 more minutes before we conclude tonight's town hall. But I want to give a few more shout outs. Captain Johnny Walker, we see you from the 15th Police District. We thank you for being on tonight. Cassell from Alpha Kappa Alpha Sorority Incorporated. Kristen, our good friend from Point Breeze Town Watch, thank you for being on. And one of our colleagues and great friends, Toby Downing from North Central Victim Services. So glad to have you on tonight. Patricia, our next question is coming from Angelica Hendrick. She raises this question: how many of the wrongful convictions are related to police misconduct specifically?
So I don't want to kind of be nitpicky about the question, but I do know that some people will define police misconduct differently. So I want to, as I answer the question, kind of define it for you guys so you understand the context of the answer. In short, before I do that, I'll say a lot of our exonerations so far involve police misconduct. And the definition I'm using is actually a pretty broad one. It is police misconduct where a police officer or a team of officers have used interviewing and interrogation techniques that are not reliable. We consider that to be police misconduct. I will note, I want to be careful, because when we say misconduct, I think a lot of times people infer that we're talking about some intentionality on it. I'm not. I think misconduct is not always going to be intentionally. It could be something that is reckless. So please understand that when I answer the question for you the way I'm answering it tonight. But yes, it's a lot. It is, as I said, the bad interviewing, the bad interrogating. And probably even more significant than that, and that has been significant so far, is that we see a lot of police misconduct in the sense that what we call as lawyers Brady information is not ultimately disclosed to the defendant and his lawyer at the time of trial. For those of you that aren't, old pros at the criminal justice system, when I talk about Brady information, what I'm talking about is information that is in the possession of law enforcement that is favorable to the defendant. And favorable means it's something that could say, this person didn't commit the crime, this other person did. It's something that could be calling into into question the credibility of one of the witnesses that's testifying against them. And it could also be something that mitigates regarding not only the culpability of the crime, but what the sentence should be. So often, and Sam, I don't know if we've done a number check lately, but I would say the majority of our exonerations have involved this kind of misconduct. Police have that kind of information, and for whatever reason, it doesn't get turned over to the defendant and his lawyer. And most of the time, what we see is it doesn't even get turned over to the prosecutor to even allow the prosecutor to turn it over to the defendant and his lawyer. And that, in my mind, is probably some of the most kind of egregious misconduct that could be committed, because we've had on the books since the 1960s, the United States Supreme Court in our country telling us that a fundamental right to due process involves getting this information before trial so that you can figure out how to use it. And so the fact that we sit here in 2021, and I tell you that I think so far is what we've seen as the most prevalent misconduct, is terribly, terribly disturbing to me. And it's disturbing because so much of it could be just educate better. Make sure law enforcement understands so that they are actually turning over the information.
Next question is coming from Meredith from Kensington Kappa High School. Given that the CIU is a part of the DA's office, are its staffers essentially investigating their own colleagues? How do you ensure autonomy? And is this part of the reason that convictions are overturned at a relatively low rate?
So, kind of as an introduction to the answer to that question, conviction integrity units have only existed for about 15 years. And when they first were created, most people involved in kind of the discussion didn't believe that they would ever take off or exist for as long as they have. And the reason for that goes to the heart of your question, which is, I'm going to use the analogy, asking a prosecutor to do this kind of work is akin to having the fox guard the hen house. So many people believed that prosecutors would not have the stomach, the desire to say when their colleagues did something wrong. So that was the prevailing thought for a long time. And I will tell you, there's still plenty of people that think that. But the reality is that has been overcome, and it's been overcome because we've seen units who can do it effectively. And I will say the Philadelphia CIU does it effectively. We are absolutely committed and determined to be in the prosecutor's office, but be able to objectively look at these cases. And when a colleague has done something wrong, we're going to say they did something wrong. Now, how do we live up to that commitment? We live up to that commitment by making sure that our unit stays independent, making sure that our unit gets the tools we need and gets access to the information, and probably most importantly, making sure that when we are looking at a case and it involves potentially wrongdoing of one of the trial prosecutors, we do not involve that trial prosecutor in any decision-making in our case. They can't have any decision-making. The same holds true with appellate and post-conviction prosecutors. Keep in mind that if you have a trial prosecutor that engaged in misconduct that resulted in a wrongful conviction, and we're talking that happened 30 years ago, that wrongful conviction is allowed to survive because the appellate post-conviction prosecutors spent decades defending the conviction. So just like we won't get the trial prosecutor involved, we're also not going to get that appellate prosecutor involved. We're going to wall them off. The only time we're ever going to bring them in is when any of them could be a witness and we need to talk to them to gather information to actually work the case. So absolutely, the question is a good one. And it has been asked over and over again by many people. Some units can successfully do it and some are not quite so successful. One reason, in addition to all the things I just said, one reason why this unit I think is successful is because Larry Krasner understands it. He has given us our independence. He lets us report directly to him, and he supports what we're doing. He understands it and he gets it. And I think it felt like there were 3 parts to that question, and I'm hoping that I got all of them.
Thank you so much, Patricia. Just before going to our next question, I want to give a shout out to Andrea Custis, who is the CEO and president of Urban League of Philadelphia. So glad that you're on tonight. Patricia, this next question is coming from Laura from Westminster Arch. As a daughter of a police officer from the suburbs, I cannot imagine how hard our police have to work in this city, and I appreciate all they do. With that being said, I'm wondering if the CIU or if the Conviction Integrity Unit is autonomous from the police department so that they can maintain their integrity and fairness.
I think the answer to the question is very similar to the one that I just gave, which is you've got to have the autonomy from the trial prosecutor or the appellate prosecutor that had their hands on the case, just like you have to have autonomy from the police officer that investigated it. So we are not going to go to, let's say, once again, it's a homicide case that we're looking at and the detective is still on the force. We're not going to go to that detective and say, help us figure this out. Instead, what we're going to do is we're going to investigate it independently. And the only time we are going to go to that detective who's still on the force is if we need to for purposes of an investigation and they're a witness, or if there's some chance that that detective may have some documentary or physical evidence that we need in order to conduct our investigation. So we are very, very, very careful. And that, just like the prosecutor scenario, is very common for most units around the country. They try to wall off the law enforcement agency that actually did the original investigation that led to the wrongful conviction.
Next question is coming from Emily from the U.S. Equal Employment Opportunity Commission. What is the Conviction Integrity Unit doing to review more cases of Hispanics with claims of wrongful conviction?
So the short answer is I can't tell you that we're doing anything to do that, but I got to explain why I give you that answer. I give you that answer because at this time, we don't have a database, we don't have a system to where we're able to say, okay, of the 2,000 cases in our queue, 400 of them are Hispanics that are claiming they were wrongfully convicted. So we just don't have that kind of demographic information at our fingertips. At the same time, I will tell you that the way we do jump into looking at the actual applications, we don't, when we look at it, we're looking at it for the information regarding the underlying case and the claims. And Sam, I'm going to ask you this because I want to make sure I'm not just speaking, out of turn in how I do it. But I very rarely, when I look at a case, I don't know if the individual who's convicted is Black, white, or Hispanic. Obviously, you figure it out when you start looking at it necessarily. You open up a file and you're going to see that information. But that's not data that we're looking at when we first start looking at somebody saying, hey, help me. That doesn't mean we don't need to get there at some point. I'll say it's an interesting question because when I was working in Texas, I actually worked with some folks trying to get grant money to try to make sure DNA testing was available to Hispanic individuals in prison in Texas because there had been some studies done that they were underrepresented in terms of getting legal representation in a post-conviction setting. So I certainly think there is a place for it. I just don't think we are set up yet for doing that kind of review. Right now, we're struggling to do the kind of reviews that say, hey, we know this one particular cop did bad things. How do we find all the bad cop cases to look at?
Just to jump in, I wanted to just give you a practical answer and say that we do have Spanish applications that we can send out. And if anyone ever needs our application in any other languages, we do have the ability to get them translated. So the best way to get in touch with us would just be having a family member or loved one call us and ask, or, you know, the individual themselves can send us a letter and say just that.
Patricia and Sam, both Minister Glenn Wilson, who is a police chaplain out in the 19th District, as well as Angelica Hendrick, raised the same question, and that is if there is any finding of any police misconduct, are there any other units within the DA's office that that information is referred to for investigation?
So investigate. So I'm not sure I understand the question, because what we do is when there is a finding of misconduct, several things can happen. One, of course, is do you look at it to see if it rises to the level of criminal conduct? And certainly our Special Investigations Unit looks at that. Separate from the question of criminal conduct is, well, does the misconduct call into question that officer's ability to testify in a pending case? It may very well. And so we've worked very hard coming up with our police misconduct disclosure database. And we're trying to make sure that that finding is information that prosecutors are considering when they make decisions about whether or not to prosecute a case. And we're making sure that the prosecutors have the information to disclose to defense lawyers so that defense lawyers can figure out if they use it. So we are trying to make sure that we are gathering that information and that we're using it for purposes that we think it should be used for in the office. One area that we're having particular difficulty with is when we talk about misconduct. I don't know if anybody saw the case that was in the news a few weeks ago, but it was Tremaine Hicks. And it involved a case where there was misconduct where officers testified falsely about the circumstances of shooting Mr. Hicks. So we gather that information, we make sure we put it in the police misconduct disclosure database, and it's helpful for new cases. And what we're working on is trying to figure out how do we make sure that separate from the Conviction Integrity Unit, our Law Division, appellate and post-conviction prosecutors are also getting that information so they can be making an assessment whether or not any of the past convictions they're reviewing might be tainted by that misconduct.
Patricia, you mentioned the Special Investigations Unit. I know that's language that's known to those of us who are on this phone from the DA's office, but can you just talk about the role? I know we're talking conviction integrity here, but the role of our Special Investigation Unit.
Absolutely. So our Special Investigations Unit is a unit set up of specialized prosecutors and investigators and support staff who really look at, I'm going to say, public corruption. And that can be very broad. I think what we are seeing more than anything else is when it is allegations that police officers have been involved in some sort of criminal conduct. The Special Investigations Unit is tasked with taking that case from the very beginning to the very end, whatever that end may be. And it's really a pretty unique unit because most units in the office are not doing the investigations themselves. Most units in a prosecutor's office, trial units, they're actually taking cases after police officers have investigated it and brought it to them to prosecute. But the Special Investigations Unit, generally speaking, is starting at ground zero, taking the investigation and seeing where it takes them in terms of did criminal conduct occur, and if in fact it did, what is the proper or appropriate outcome in regard to that particular officer.
Thank you for that response. Here's the last question for tonight. Can you describe, and it's coming from Nancy, a community member, can you describe any pattern to wrongful convictions in CIU that CIU has had been overturned?
Sure, and I'll just quickly say, nationally, we've studied wrongful convictions now for quite some time, and we see patterns throughout the country. And essentially, what the research has told us in regard to those patterns is we see the same thing over and over again, and it's going to be eyewitness identification error. It's going to be official misconduct. It's going to be perjury or falsified information. It's going to be junk science. It's in junk science is when, unfortunately, prosecutors rely on evidence and they kind of elevate it to say it's science, therefore this person is guilty. Bite marks are a good example. So that's kind of what we have seen nationally. I'll tell you, when you start looking at individual jurisdictions, sometimes it looks a little different. So, for example, you could have in some jurisdictions where they're using more junk science than others. In Philly, what we are seeing, I think, most often is problems with eyewitness identifications, interviewing and interrogating such that we end up with unreliable either witness statements or confessions. And then, as I said a little while ago, the official misconduct, and that's kind of a big bucket. And what I'm referring to specifically are the Brady violations. It's when we are seeing that law enforcement is not turning over that favorable information that's material. And they're not turning it over to the prosecutor, or sometimes we see it gets turned over to the prosecutor and the prosecutor doesn't turn it over. Not seeing a lot of the science because, unfortunately, I just don't think Philly has been a city that has relied on science enough such that you would have problems with using junk science. It doesn't mean it doesn't exist, but I just don't think it exists in the numbers that we see in some other locales.
Patricia, last thought here. Any final words you want to give to our viewers tonight, and what inspires you personally to do the work that you do each and every day?
So it's tough to say, what are my final words? Oh gosh, what inspires me is people like Chester Holman. If any of you guys have met him, I don't need to say anything else. What inspires me is I've always cared about the criminal justice system and wanting to help. And I thought for a couple of decades that meant representing individuals accused of crimes. In the role I'm in now, as much as I love doing that, in the role I'm in now, I am inspired by the fact that I finally have the resources and, quite frankly, the power to help people on a level that I don't know that I ever could as a defense lawyer. And a lot of that inspiration comes from, quite frankly, Larry's mission and his dedication to righting the wrongs of the past. One last thing I'm going to say, I'm inspired by the community. I'm inspired by my community of people that care about these issues and show up to something like this and want to learn more and want to help. All of that makes me think, as bad as I think it is sometimes when I see these terrible miscarriages of justice, it makes me think we can do it. We can do better. I know we can do better.
Patricia, Sam, so glad to have you both on tonight, and I thank you for taking the time to share with our listening audience. To all of our stakeholders, I'm going to ask that my assistant Seth Myers, that he puts both my contact information as well as his own contact information into the chat feature. We want to hear your feedback from tonight. And we know that many of you asked lots of questions. So the majority we tried to answer tonight, but of course we were limited as far as time. But we want to thank you for tuning in and for being a part of our community, our virtual community town hall this evening. Feel free to reach out to myself or Seth Myers with any follow-up questions, or if you just want to give any feedback tonight. Know that every month we have our virtual town halls, and we're highlighting the work of amazing and extraordinary people in our office in their units that's doing some amazing work. Follow us on social media. Seth's going to also put our social media handle in the chat feature. But we're on Twitter, we're on Facebook, we're on Instagram. Follow us at DAO. That's PHILADAO. And we certainly want to hear from you. Each month, of course, we're having our virtual town halls. We host a job and resource hub called One Stop. Connect with us so that we can get more information to you. And if there's a community meeting that you're hosting through one of your civic associations or your community organizations, let us know. The DA's office, we want to be your partner and know that we're here to serve and support you. So once again, special thanks to Patricia Cummings, to Sam Bass, to our partnering agencies that joined tonight. And thank you all, our listening audience, our community, our residents, our stakeholders. We appreciate your partnership and we look forward to talking to you soon. Peace.